All right, let's get started. So good evening, everyone. Thanks for joining us. My name is Sarah Block, and I am the Senior Development Manager at Brooklyn Legal Services Corporation A, or Brooklyn A. Just want to begin by acknowledging that, I know this is a hard time for everyone. And I want to thank everyone for what they're doing in their personal lives, professional lives, families, communities, to maintain stability and get through this all. So tonight I welcome you to What Happens Now, Life After the Eviction Moratorium. This event is just one event in a series of town halls that we do for each of our programs. We find at Brooklyn A that it's really important for us to have a space to share clear and accurate information and to be able to answer questions around our rights during this confusing time. These virtual events are part of our efforts to do outreach to our communities and to convene that space. Since April 2020, we've hosted over 90 events. And we thank many of you who have come time and time again, who've been with us following all of the updates and changes, as well as to our many partners who have partnered with us along the way, including elected officials and community-based organizations. Can you move to the next slide, please? We'll go through some introductions of our special guests this evening, and then we'll move right into the information about lifting the moratorium, status of housing court, right to counsel, status of evictions, and then move into a question and answer section. Next slide, please. So maybe you've known about Brooklyn A for a long time, or maybe you just heard about us today from a social media post. But we're happy that each of you are here and want to offer a brief background on who we are. Since our founding in Williamsburg, Brownsville, and East New York in 1968, Brooklyn A has used high quality, low barrier, neighborhood-based legal and advocacy tools to disrupt cycles of economic and racial injustice. We represent low and moderate income individuals and families throughout New York City, even though our name suggests just Brooklyn. Our clients live in rapidly gentrifying neighborhoods where many residents and small business owners face displacement and harassment. In the last year alone, we served close to 13,000 residential tenants, homeowners, taxpayers, and small business owners through our 3 program areas. Tonight we'll be speaking specifically about our work around tenants' rights. But we also do work for taxpayers where we resolve issues with the IRS in New York State. We work with homeowners to prevent foreclosure, to prevent scams and deed theft. We also work with small businesses on commercial lease assistance and other kinds of transactional legal services for small businesses and nonprofits. Also, beyond eviction prevention work that we do with tenants, we help to do tenant organizing and as well as repairs and restoration to essential services. So if you or anyone that you know needs help, feel free to reach out to us. We are open Monday through Friday, 9 a.m. to 5 p.m. You can reach us at info@bka.org or call us at 718-487-2300. It's really important for you to share this information with your families, with your neighbors, because you never know who is going to need this help. Next slide, please. So this evening's presentation is sponsored by New York State Senator Julia Salazar and Councilmember Sandy Nurse. These are key partners of, oh, let me move Sandy over. I'm sorry, I see you over here. So these are key partners of Brooklyn A, and we thank the senator and council member for their steadfast support of Brooklyn A, for elevating resources for tenants, and for sponsoring tonight's event. So I'm going to start with Councilmember Nurse, because I know that you have another event to be at. So want to welcome you. Thank you so much for your support, and also want to publicly congratulate you on your new position.
Hi, good evening, everyone. Thank you so much. Let me know give me signals if I'm doing if you can hear me.
Yes.
I'm in a little corner that's kind of a dead spot.
We can hear you well.
Awesome. Well, I just want to thank Brooklyn Legal Services for all the work that you do in making sure New Yorkers and folks in Brooklyn and beyond are taken care of and have access to support and have a place to go to walk through the next steps when they're in a very, very challenging time. So just a small thing, our office is opening up in February. We'll be there for in-person, but I will drop in the chat our contact information. So please feel free to reach out to us and we can help as best as we can. And thank you, Brooklyn Legal Services, for having us here.
Thank you so much, Council Member. We appreciate your support. And now I'll pass it over to Carlos Calzadilla, who is from Senator Salazar's office.
Hello, everyone. I hope you're all doing well this lovely evening. On behalf of Senator Salazar, I want to thank everyone for being here, and for Brooklyn Legal Services Corporation A for putting this wonderful event together, and the incredible work they do every single day for tenants. This legal support that they provide is crucial, and we couldn't do our work without them. You know, the senator has really been a fighter for tenants' rights, and has passed super expansive protections, including the 2019 tenant protection laws, and has been a very strong vocal voice for the eviction moratorium that unfortunately has expired, but has protected so many millions across the state. Now, you know, North Brooklyn is his home to so many tenants and is the front lines in the battle for fair and just housing. And our office works hard every single day to help tenants, ensuring that they have the support that they need when facing harassment, eviction, lack of repairs, and other housing related needs. And what helps us do this work is Brooklyn Legal Services and other amazing community partners that helps us in making sure that they have the legal resources and support that they have. Our office is really driven by the belief that housing is a human right, and dignified housing, and Senator will continue to do so, and everyone in our office. We want to make sure that everyone knows all the information that they have, that they are informed. You have rights, even though the eviction moratorium has ended. The ERAP applications are still live and open, which means that just by filing, you may still be protected if it's due to non-payment. We want to make sure that everyone feels supported. Our office is here to support you. The senator is fighting hard on good cause eviction as well to expand those protections. I'll drop all the information in the chat, and then the next week or two we'll be opening in person as well. So again, thank you so much to Brooklyn Legal Services Corporation A for this wonderful event.
Thank you so much.
Thank you, Carlos. Really appreciate it, and appreciate the support of the senator and your office. Okay, now I'll turn it over to Christy Ortiz-Lamb, who is the director of our Preserving Affordable Housing program. Just also want to shout out that Christy is working tirelessly during this time, as many of us are, and want to appreciate her for all the work that she's doing.
Thanks, Sarah. That was nice. So we're going to start off by discussing the lifting of the moratorium. As you know, the moratorium was a protection that was initiated to protect tenants who were facing financial or medical hardship due to COVID-19. As a result of that hardship, there was a stay in place preventing them from being evicted from their homes. That stay was lifted January 15th for 2022. That means that evictions can move forward, particularly for everyone that's living in New York State. Evictions can proceed, but there are safeguards put in place by the court so that there isn't a floodgate of evictions that are happening. The way that you can get evicted is if you have a current housing court case, you entered into a stipulation, or there was a trial, or you defaulted, meaning you didn't show up in court. That means that there is a judgment and a warrant against you, and the landlord can petition that a sheriff or a marshal in the city of New York actually put a notice on your door and come and lock your doors within 14 days. You will get something in writing, and it generally will be posted on your door. And if you do get that, then you can file an order to show cause to actually stop that from proceeding. But there are, as I said, safeguards and directives that have been issued by the court. The two directives, it's DRP 213 and 217, were during the moratorium, and those were protections that required a motion be filed before an eviction could move forward. That has now been modified by 221 and 222, which allows for cases that had judgments prior to March of 2020 to be able to move forward without a motion. There are certain criteria that have to be done. There has to be a conference that was actually had during that period. If they're not, then you could actually get the eviction stayed. However, if there was a conference, then the marshal should be and is allowed to provide you a notice to be evicted from your apartment. We do also have Administrative Order AO 34, which provides guidance with different types of proceedings in housing court, and also with the ERAP, which allows, ERAP is the Emergency Rental Assistance Program, which allows folks who've been impacted financially by COVID to get rental assistance. There currently isn't funding for the 5 boroughs, but we're hoping that in March there will be an influx of money that's coming in. So the application process is open and accepting applications for folks in the 5 boroughs. So you should definitely apply. And if you do apply, you'll get an application number, and then that will stay the eviction in your case. And there won't be an eviction in your case until there's a determination made by the Office of it's OTDA. I'm going blank on what OTDA stands for, but it's the Office of, I'm just gonna let it be. So it's OTDA. However, that stay does not apply if you are facing an eviction for nuisance or for damage of property. So if the landlord is saying that you have a lot of possessions in your apartment and it's causing like a smell, or it's impacting the other people within the apartment, or there's assault or violence, or you've been damaging the property because of like a massive leak, those cases actually are still moving forward regardless of the ERAP stay. So definitely reach out to an attorney if you have those types of cases. You can reach out to us directly, or you can call 311. So Judge Marks also sent out a memo dated January 17th, 2022, which also provides guidance. And we can provide all of these, the directives, as well as the administrative orders and the memos for anyone who would like to see them. They are also on the court's website, and it's public knowledge. So everyone can and should be fully apprised of the new directives. So housing court is open and accepting all filings. Anything that it accepted prior to COVID, it's accepting again. The clerk is open for pro se filings from 9 to 4:30. There has been sort of a shortage of clerks in housing court right now because of the rising levels of COVID. So it may take a little longer to be able to get somebody on the phone or to be able to see a clerk. But they are accepting cases, and you definitely can apply virtually. You can also apply for order to show causes in person. So definitely you have that right, and you can go to any of the courthouses. They're all open. Right to Counsel is an initiative that started with the mayor about 6 years ago. And it was passed this past, I think it was 2020 when it was finalized, which allows for every New York City tenant living under 200% of poverty to receive free counsel. The court has created a number of different intake parts, which would basically align you with a new legal services provider. So the minute you have a court appearance, you would actually be assigned an attorney. That attorney will reach out to you, try to get you representation. And then if that doesn't work, once you're transferred to a resolution part, the court once again will try to set you up with counsel as well. So everyone does have that right. And there are waivers that most legal services providers can actually ask for. If, for example, it's sympathetic, you've been living in your apartment for more than 15 years, you're elderly, or there's a disability, we could request that the income limit be waived. So there is hope for folks who are living above 200% of poverty. And then once the case is filed, as I said, you will be assigned an attorney, and then that relationship will start. If you don't want to wait until you actually get a court case, you can reach out to 311, and they have a hotline which allows for advice to for any type of housing questions, regardless of the borough that you live in. We are a party of that hotline, and so we can answer your questions. Also, you can reach out to 311. They have the names of all the legal services providers, and they'll direct you to the Human Resource Administration, which will allow you a connection with one of the legal services providers in the city. So those are options. In regards to evictions, as I said earlier, a landlord can get a judgment and a warrant. That means basically a paper that says that they can change the locks. They can get it in 3 ways. A default judgment means you didn't appear in court. This happens sometimes when you don't get the mailings. For example, the landlord doesn't give you your mail or has like changed the locks to your mailbox. Or you're actually staying in a different place right now because of the conditions in your current apartment. So you actually don't get the mailings. There's a number of reasons why you didn't get it. And so because of that, you defaulted. You didn't show up in court. But if you get notified that they're coming to change the locks, you can reopen that default and just explain that you didn't get the papers. And that you have a defense to the underlying case. Another way that the judge can grant a judgment and a warrant is after an agreement. You enter into a stipulation with the landlord. You basically say, I'm going to pay at this time and this amount. And if you don't pay, then they get a judgment and warrant. If, for example, they say that you have to move, you get 3 months, 4 months, 5 months to move. And if you don't move out, then there's a judgment and warrant against you. Also, if there's a trial, a full-on trial where you present all your defenses and the court finds against you, then you can get a judgment and warrant against you. So once you receive the judgment and warrant, then the marshal will be contacted and they will serve on you a 14-day warrant of eviction. They will serve that on you by regular mail, certified mail, or even posted to your door. And then if you receive that, you can file and should file an order to show cause for an extension to move or to pay. You have to have good cause for why you need an extension. For example, you've been looking for an apartment, you can't find one, and you provide the court all the resources that you've tried to use, like you hired brokers, you've seen a lot of different apartments, you provide the phone numbers of all the landlords that you reached out to, or in forms of payment, you show I've applied for HRA, I've asked my family friends to help me. These are the money orders that I have put together. This is the savings that I have. I've asked for a loan from my 401k, whatever resources you actually have, you just let the court know that you are working towards making those payments. And then the court will grant you an extension if you can show good cause. Lastly, our contact information, as Sarah said earlier, is 718-487-2300. Our website is www.bka.org. And then you can definitely email us if you have any housing law questions at info@bka.org. So I'll turn it back to Sarah.
Thanks, Christy. Thanks for moving through all of that. All right, so now we'll open it up to questions. You can either put them in the chat or into question and answer section. Or if you're watching on Facebook, you can put it into the chat there. I can see them. Or if you would like to be unmuted, you can go down to the participants section on the bottom of the screen and press that little hand button, and I can unmute you. Okay, there was a question about people who owe rent for commercial rent due to COVID, and I had answered that, yes, our small business support program could potentially help with that. And so you can send us an email to info@bka.org. Question is, are there protections for people in foreclosure? Yes, we are, our consumer and economic advocacy program, which works with homeowners, are helping people to apply for HAF assistance, which is financial assistance for homeowners. And that program can also let you know more about the protections that you have for foreclosure. Does HAF assistance stop the foreclosure? It does not. Actually, you can reach out to our attorneys to answer that question. And we also have done a couple of events recently on that topic, and we can send you a recording. All right. All right. How far behind are housing court hearing loads? I'm guessing that it's asking what is the backlog looking like?
So the backlog is pretty extensive. For holdover proceedings, they're still trying to calendar cases that started after March 2020. So it's looking like a couple months before you actually get a court date, but the courts are pushing to try to get those calendared pretty quickly. So.
Okay. What are the next steps after receiving a notice from the landlord attorney?
So it really depends which notice. So if it's a predicate notice, meaning a termination notice, 14-day notice, a 30-day, 60-day, 90-day, or 10-day notice, that's just the first step of the process. And so you would have to wait for the next step, which is a notice of petition and petition. That generally has an index number on the top, and it'll tell you what type of case it is, and that will give you the next court date, or it will tell you that you have to file an answer within 10 days.
Great. Okay. Does your office only help with evictions in Brooklyn or other boroughs as well?
Unfortunately, at this time, it's only Brooklyn.
For housing or for tenants?
Only housing, for housing, yeah.
Yep. Okay, and if someone is watching from that lives in another borough, what should they do?
You can definitely call 311 and they can refer you to another legal services provider. You could also reach out to the Human Resource Administration, and it's called OCJ. That's the program that is running the right to counsel, and they can refer you a legal services provider.
Great. Is Homebase still helping with rental payments?
Yes.
Can you explain what Homebase is?
So Homebase is a program that's sort of like the branch of the the Human Resource Administration, which provides for different rental assistance programs like FEPS, city FEPS. They also will help with cash assistance, sometimes shelter allowance. And so the three programs that do or are Homebase are Catholic Charities, Riseboro, and Canva. And so, yes, they do, but there is a backlog. And so I know it takes about 3 to 6 months to even get an appointment now.
That's good. Okay, information on applying for housing vouchers while facing eviction.
So we do not help with housing vouchers at this time. We generally refer that out to community-based organizations. We have a partner, Cypress Hills, local, help me, Sarah.
Local Development Corporation.
Local Development Corporation, and they actually help folks with vouchers.
Great. So should folks come to us first, and then we can refer them over to Cypress Hills?
You can do it that way, or you can reach out to them directly. I know there's a lot of different community-based organizations. I'm sure Salazar's office, as well as nurse's office, can probably also help with different programs that are helping with applying for housing vouchers.
Carlos, is there anything that you want to add there?
Yes, yeah, there's a lot. Definitely, I encourage anyone to email or call our office. We help with, there's a lot of variety of vouchers depending on a lot of factors. So we can definitely help them. There's also some cash assistance that some tenants might be eligible for. So our office definitely helps anyone that needs this information or needs help applying.
Great, thank you. For people facing eviction, do we have a specific format for CBOs to use for phone intake or messages? And I guess what kind of information should be included in a referral?
So the client's contact information, phone number, address, and what the issue is. That's really all that and the client's name. That's all we need in order to be able to do an intake on our end. And I believe that we have a new system on our website that you can make direct referrals.
Okay. Someone applied to ERAP and still has not gotten a response. Any advice there?
So they say it takes about 6 to 8 weeks to get a response. I know that if you've applied after November 16th to ERAP, you may not get a response until March, because that's when the additional funding is coming down. But if you actually applied before November, I would reach out to the hotline number and ask for status, because it might be that your landlord actually didn't complete their portion of the documents that needed to be submitted. And if that's the case, that may delay the processing of your application.
Does the landlord need to send a hardship declaration form with the late notice?
Not anymore. That was the rule that they had to do prior. Based on the administrative order that was sent out, it's just the resumption of everything that was required prior. There is a requirement for AO 24521, which I can open. But I don't believe that's going to be an immediate dismissal if they don't include the hardship.
Okay. What are the thoughts about tenant organizing?
Can you give me more on that?
Johnny, do you want to talk about tenant organizing?
No, is it like just we encourage it? I think everybody should organize, and we are available to help folks to organize if you are interested in us helping.
Yes. Johnny, if there's anything you want to add, feel free to do so. All right, let's see. Is it confirmed that there's more money coming in for ERAP?
I heard that we have confirmed 27 million.
Awesome.
And I know the governor was pushing to get more federal funding, but I haven't heard anything about that.
Okay, what is the time log for eviction cases that were assigned court index numbers already?
So it depends. If it's a non-payment case, most of those cases are being placed on the calendar right away. If it's a holdover proceeding, and it did not actually have a date on the notice of petition, the court is actually scheduling those in Part I, and it is taking months to get through it. So you will receive a postcard in the mail when the court actually schedules it.
Great. Okay. Yeah, so Ashleen, I think that in terms of still waiting for ERAP, just what Christy said before, just, we check in with them. And I guess reach out to us if you continue to not hear back.
So
Okay.
just to go back a little bit to that question,
Mhm.
this is just an example. So a landlord filed a notice of petition March 22, 21, and we just got a date for February for that case. So just a heads up.
Okay, so it's taking a while. Okay. So so another question for that a homeowner has. There's a question around how to know if a conference is scheduled for homeowner and foreclosure case. You can feel free to reach out to us at info@bka.org so that we can direct that question to our team that works with homeowners, as well as for small businesses. I know there's a question here about that a commercial tenant has.
So for the foreclosure, it's the same process as tenants. So you should be getting a postcard in the mail if that is coming up. Also, there's a website called eCourts where you can actually input your index number. So you just put eCourts on Google. It's like the first thing that pops up. You click on it, click on Supreme Court, put your index number on, and it'll tell you the next court date for your case.
Also, we want to let people know that the New York State actually has opened up the New York homeowners insurance program, and it's over $500 million for eligible homeowners to apply who are facing these types of foreclosures and issues. So I'm gonna grab it and put it in the chat as well for people. We encourage people to apply as well facing that.
And that's for co-op and condo owners as well.
I'm not 100% sure, but I'm sure the hotline that they have.
No, it definitely is.
Oh, it is? Okay, perfect.
Yeah.
Excellent. I'll drop it in the chat.
Thanks, Carlos. Okay, let's see. Anything else? Just seeing if I missed anything.
What was the small business question? Maybe I can help.
The small business question was, as a commercial tenant, is voucher-based equivalent for a commercial tenant? Maybe is there an equivalent to housing vouchers, or yeah, you know what I'm saying, trying to say.
So I honestly don't know of any for businesses.
All right, thank you for, let me put that for everyone, Carlos. All right. Can one still apply for the COVID-19 protection?
So yes, you can. So you still can fill out a hardship declaration. The hardship declaration doesn't allow for a stay of your case, but it will let the court know and your landlord know that you've suffered a financial hardship due to COVID, and that will provide you a rebuttable presumption in your case, and it's a valid defense that you can raise. So yes, you should still fill out the forms.
Okay, we have a participant who is negotiating a cash settlement for a client in a holdover proceeding, provided he moved by a certain date, but he does not have the money for the first and last month's rent. The cash is not available until after move. Any suggestions?
So I think you can actually ask for a little bit more, or ask for a payment up front in order to help you to move. And so then you can negotiate like $2,000 or $3,000 prior to move out. And most landlords will agree because they know that you need money in order to move.
Great, thank you. What happens if someone is approved for ERAP, but the landlord refuses to cooperate with the program?
So you are protected for up to 12 months, and the landlord cannot sue you for the money he's rejecting. So if they approved you for 15 months, then the landlord can't ever get that money.
Great, it's a good question. Okay, I think that might be everything. If anyone thinks of another question, and oh, another one pops up. All right, can you talk about some of the possible COVID-related defenses to non-pays, like the Tenant Safe Harbor Act, etc.?
So if you look at the memo that was issued by Judge Marks, it actually goes into great detail about that. I'm trying to open it up. So you have a rebuttable presumption, which is what I said, due to filing the hardship declaration. The Tenant Safe Harbor Act actually raises that presumption, which you can raise. Also, that the landlord can't technically sue you for the money that ERAP would have paid. Sorry. I think this is perhaps like a one-on-one question. I can actually give you much more information that way, but I'm like really going blank right now. Sorry.
Okay. Okay. And also a quick shout out to Assemblywoman Frontis from the 46th Assembly District. Representative is here with us, and thank you for joining us. How can we get a copy of Judge Mark's memo?
I can share all that after this. I can send the DRPs, the administrative orders. Yeah.
Okay, so we'll be sending out a copy of a recording of this presentation and all of those resources to you all tomorrow.
So just to go back to that other question, so the Safe Harbor Act extended from March 7, 2020 until January 15, 2022. So no court shall issue a warrant of eviction or other judgment against a tenant that has suffered a financial hardship during COVID for periods of non-payment of rent. So a tenant may raise a financial hardship as an affirmative defense in the case, which is what I said before. And then the Tenant Safe Harbor Act, however, does not prohibit any court from awarding a money judgment. So they can't be evicted, but there can be a money judgment against the person. So the difference between a possessory judgment and a money judgment, possessory judgment means that they can physically move you out of your apartment. And a money judgment is just a judgment that hangs over your head for 20 years and can impact your credit and make it difficult to be able to buy a car, or and it just sticks around for 20 years.
Okay. Is it on the tenant to prove their hardship? Or does the landlord need to prove it?
So it's a rebuttable presumption, which means that it's true unless the landlord can rebut it. Prior to the lifting of the moratorium, there was a lot of landlords who were trying to basically dispute the hardship declarations, and the way that the statute allowed them to do that is to show that there was good cause, meaning, or a good faith reason to believe that it wasn't true. Meaning the landlord had the burden to show that you had a job during this time, that you actually didn't suffer financial hardship because of these reasons, or the medical aspect of it, that you don't actually have a condition that would make it a higher risk if you were made to move, a higher risk of dying or having serious illness due to COVID. And so it is your defense and it is the landlord's burden to prove that it's not true.
Awesome. We have a question for Carlos. What is the status of Senator Salazar's bill to expand good cause eviction?
Yes, thank you so much for that question. Well, first of all, the Senator is working very hard to pass the good cause eviction bill. It's a top priority for the Senator in our office because of the incredible protections that it will expand. In terms of the status, first of all, there's enormous work being done statewide to get the good cause eviction bill passed, with so much outreach being done across the state to tenant organizations, advocacy organizations, the labor movement, and there's been a lot of lobbying of members of the legislature, and especially with the eviction moratorium ending, there's even more pressure for good cause bill to pass. You never really know what can happen in a legislative session, but the Senator in our office, we have cause for optimism, and if tenants would like to support and help pass this bill, definitely encourage people to call their local state legislators and even the governor's office to support the passing of it. Now, I saw another question in the chat about talking about some specific provisions that the bill provides. One of the things that's so important because it helps keep people from being evicted, especially when a lease ends. A lot of times, currently, there's not that much protection if a landlord wants to evict on a holdover proceeding. That is harder to do under good cause eviction. They have to show good cause. Now, non-payment is a good cause. So definitely that's something that this is a nuanced bill, but they can't just evict individuals, and you have that presumption that tenants deserve housing stability. And unless a tenant violates some basic rules of agreements such as property damage and being a nuisance, but overall it's very strong protection. Also, in terms of increasing rent, it's either two options, whichever is greater, of either 3% of the current rent is what only can be increased, or 150% of the consumer price index, which is basically a measure of inflation, which can be somewhere around 6%. These guidelines are a presumption that anything above that is unreasonable and not permitted, which is a very strong protection from getting the rent just raised at levels that make absolutely no sense and force basically people to have to leave their homes. However, if a landlord can actually justify that sort of increase, they would have to justify it to a judge. So what this does is really place protection so that landlords cannot just start an eviction proceeding. It's really groundbreaking in the protections that it gives, but it's also not like a complete stop. Like, there are avenues if there is a good cause for landlords, and it does protect small landlords if they're owner occupied or 3 units or less. That would not be included in this, but for all other units, it is protective. Would be very expansive and very, very protective, and definitely the Senator in our office are working very hard to pass it. It would really shift the balance so that it's much more fair to tenants.
Great, thank you, and thank you for your advocacy on that. Is it for New York City or New York State?
It's a statewide bill, so it would be for the entire state of New York.
Awesome. Okay, and someone suggested that you can look up if you're in New York City, you can look up your legislative rep at www.mygov.nyc.org. You can also go on the Who Represents Me website. All right. So Wilhelmina, I'm not sure if I understand your question. What do you do when your landlord gets $5,000 from tenant and about $8,700 from ERAP and still wants to give credit only for October, but wants November and December rent?
So ERAP generally designates what months the rent is supposed to apply to, and the landlord can't deviate from what OTDA has established. If you are getting money from a different source, then that money can be allocated to whatever month. But if the months are not actually like fully satisfied, then generally the landlord will count backwards. And so you would owe the current rent. I think that hopefully that answers your question.
Great. So most of these laws protect apartments or residential tenants. Are there protections for commercial tenants?
I'm sure there are. Unfortunately, I think you can email us at info@bka.org, and then we can assign those questions to our other program area and they can answer.
And we're hoping to schedule a workshop soon on what the moratorium lifts mean for commercial tenants. So look out for that. Okay. Can a landlord send lease termination notices to month to a tenant now? And what are the consequences if the tenant doesn't leave by the given date?
Can the landlord send a month? What? Say it again.
Can the landlord send lease termination notice to
A month to month?
Yeah, to a month tenant. No.
Absolutely. Yes. He or she could have done that during the moratorium as well. There was nothing stopping that. And if you don't actually leave during that time period, it's okay, because they have to do a notice of petition and petition, and they get an index number, and then they have to go to court in order to be able to evict you. Just because you got a termination notice doesn't mean you have to leave.
Great. Okay. And if someone has to go to court, will it be in person?
It doesn't have to be in person. You can go in person if you want to, but if you received a postcard from the court, it generally provides a phone number that you can call in, or a Microsoft Teams link. So nearly all appearances are virtual right now.
Awesome. Great. Not seeing any more questions. I will end things over here. Thank you so much, Carlos, for joining us and for Senator Salazar's support and partnership.
I actually see
a
question. It says my landlord does not want to renew my lease even though I live in a rent stabilized apartment. That's illegal. He has to renew your lease. There's no choice. Unless he's trying to evict you for cause, like there's a reason why he's saying that you violated your lease. If they do not give you a lease within 60 to 90 days of the expiration of your lease, you can file an action with DHCR and force them to give you a renewal lease. Sorry.
No, you're fine. Just responding to some nice messages. words of appreciation here. Okay. Yes. And it's great to see some of our partner organizations on as well. We have Kurt Hill here from People's Firehouse, and Nora and Roberto from Lucha. We're happy that you joined us and to work alongside you. So once again, thank you to Senator Salazar's office, to Councilmember Sandy Nurse's office for sponsoring this event. Thank you everyone for attending. And thank you so much to Christy for all the information. We are here for you. If anyone has questions, anything comes up, we are here. You can reach out to us once again at info@bka.org or at 718-487-2300. You can also reach out to the elected officials' offices. Yes, we are hoping to do, we will do a webinar. We've been doing a series of webinars for homeowners, and we will be doing another one for small business owners soon. Regularly, we're doing them for tenants as well. We hope that you all stay safe and warm and well, and we'll see you again soon.
Bye, everyone.
Good evening.